Homeowners claim decades of intentional flooding in new suit. Nearly 60 Harris County homeowners are suing two state agencies for what they say has been more than 2 decades of mismanagement of the Lake Conroe Dam, flooding their houses multiple times, including from Hurricane Harvey. In a lawsuit filed Monday, families from Kingwood, Atascocita and Humble accused the San Jacinto River Authority and the Texas Water Development Board of intentionally flooding their homes with releases from the dam and reservoir dating as far back as 1994. The agencies, the suit alleges, have repeatedly violated the Takings Clause of the Fifth Amendment, which requires governments provide just compensation for any private property taken for public use. On at least 7 occasions, the suit contends, the two agencies have orchestrated catastrophic floods that have turned pristine homes into mold hazards and turned family neighborhoods into wasteland without ever compensating for damages. Neither agency could be reached for comment Monday night. The suit follows a wave of criticism during Harvey of the decision and timing of controlled releases of floodwaters from the dam, a public water supply source. Already the River Authority faces another lawsuit from hundreds of flooded Kingwood residents. Last week it was singled out by Houston Councilman Dave Martin, who represents Kingwood, for hiding behind lawyers and press releases in its operations during Harvey and subsequent responses to angry residents. While the other suits have sought damages specifically related to Harvey, the action filed Monday seeks to compensate homeowners for at least 23 years' worth of alleged mismanagement. In an email Monday, Houston Attorney Bradford Laney said he is seeking a temporary and permanent injunction to make sure checks and balances are put into place at the two agencies. "We are fighters," said Laney, who is also a plaintiff in the suit. "And we are not going to rest until the Water Board and SJRA are held accountable for the devastating floods they orchestrated. If we have learned anything in the past few months, it is that these entities are incapable of managing their responsibilities without supervision," he said. Authority response: The River Authority has previously defended its decision to release record amounts of water from the dam during Harvey and has called accusations that it was protecting certain people at the expense of others both false and offensive. "There is no question that the flows from this event were unprecedented and were highly damaging," the River Authority wrote in a statement last week. "Yes, homes were destroyed by the powerful force of the high flows in the river. To imply that Lake Conroe opened its floodgates and then homes were destroyed in the roaring floodwaters is incorrect," the statement continued. "But the suit may face an uphill battle," said Jim Blackburn, an environmental law professor at Rice University. "It's a very difficult case to win," he said. "Mainly, you're going to have to show that there was intent to flood. Similar case in 2014, and because the dam is a public water supply and not meant for flood control, the homeowners will likely have to show that the River Authority's actions were both contrary to its operating agreements and worsened the flood downstream," Blackburn said. Similar arguments were made in a 2014 case brought by other Harris County homeowners who claimed the county did not do enough to prevent floods of new homes built in the White Oak Bayou watershed. The Texas Supreme Court eventually sided against the homeowners, writing that Harris County never harbored a desire to cause flooding anywhere, and warning that allowing such litigation could discourage governments from mitigating future floods. Blackburn, who represented the homeowners in that suit, said the case law it established could be a hurdle for the action filed Monday. "It's not impossible to win," he said, "but it will be very difficult.